second part of the second lesson. And before I start formally, I would like to make a short recap on what we have covered on the first in the first lesson. First, we found out about the background of the law, the definition of a kasambahay, the rights and privileges of a kasambahay, and also the parties, the responsibilities of the parties involved in an employment contract, and also the terms that must be found in the employment contract. Now we proceed with our second part, and you will find out here the pre-employment requirements, and also it's already reflected in the screen, and also the terms and conditions that will be agreed upon, or that must be agreed upon by the parties, and also the private employment agencies. And now, as you can see in the screen, it's already shown that the following documents shall be required by the employer during the commencement or during the execution of the contract. As you can see, the medical certificate, this is to ensure that the kasambahay is not suffering from any disease that could be prejudicial to the health of the employer. And also the barangay, police, and NBI clearances, which are needed to establish whether or not the person is of good moral character, especially to rule out the possibility that the kasambahay has a criminal record. And also the most important is the proof of documents proving the age of the kasambahay. This is to prove or to avoid the possibility that those persons who are below 15 years old will be employed, because there is a total prohibition of the law, and those who can be 15 to 18 years old may be employed. Now, these shall be required by the employer from the kasambahay. Now, the following are the terms and conditions that must be agreed upon by the parties. The employer shall safeguard the health and safety of the kasambahay depending on the nature of the domestic work, and also the kasambahay is entitled, of course, to rest day. In a day, he is entitled to an aggregate daily rest of 8 hours per day and 24 hours consecutive hours of rest in a week, and the schedule must be agreed in writing, and the religious considerations must be included also, because there are kasambahay who could be Seventh-day Adventists or Muslims who have different Sabbath day, or like they observe different holiday, unlike the majority of us here in the Philippines who are Roman Catholic. Now, the kasambahay and the employer are not prohibited from agreeing on these terms as regards to rest day. There could be offsetting, there could be waiving also, but upon waiving of the rest day, the equivalent daily rate shall be paid also, and the accumulation of the rest days. But the law provides a cap on the accumulation. It should not exceed 5 days, and other similar arrangements. It's possible that rest day could just be like first 12 hours, and a different day. It's also possible. There's no prohibition on that matter. Now, what about the minimum wage? This is one of the most important terms of the contract, because upon performance of the obligation on the part of the kasambahay, he should be paid. Of course, since this law was approved in 2013, the figures as found in the law are not the recent one, and if you look at the current one is ranges from 2,500 to 5,000 pesos. That applies in NCR and in Region 7 in cities and first-class municipalities. And you have to be updated, because the current one was issued sometime in January 2020, and it's the regional tripartite wages and productivity boards which will set the minimum wage for the kasambahay. This is on a monthly basis. You have to remember this. What about the termination of the employment? it could be classified into just or unjust dismissal, and I'm showing you the effects first instead of the causes so that you would know the legal consequences, and then you will later take note of the causes, the justifiable causes. The kasambahay, if he is unjustly dismissed by the employer, he is entitled to the compensation already earned, and aside from that, to serve as an indemnity, he is given the 15-day work equivalent of the compensation. Now, what if the cause is the kasambahay and he pre-terminated unjustly the contract? Then there could be forfeiture of the unpaid salary, but the same should not be exceeding 15 days. So on the part of the kasambahay, then if the same is beyond 15 days, then forfeiture will not be applied. So, and the recovery of the deployment expenses if the pre-termination happened within 6 months from the employment. Okay, now what about in case there is no definite duration as found in the contract, or not, it could not even be determined by the nature of the service, then there could be a mutual agreement on the part of the employer and the kasambahay, but the notice to pre-terminate must be given 5 days prior to the intended date of pre-termination. Now, as I said a while ago that I first showed you or presented the effects, now we're looking into the causes. On the part of the kasambahay, since this is a bilateral agreement, on the part of the kasambahay, he could pre-terminate the contract in case of verbal abuse, inhumane treatment, like no adequate meals were provided in a day, or there's no rest period, or no board and lodging provided, which are in inhumane condition, and also the commission of a crime against a kasambahay. And you have to take note also that any violation of the contract and this law would cause the pre-termination, the valid pre-termination of the contract on the part of the kasambahay. And what if the employer, or there's a disease affecting the parties, then that could be a cause for termination of the contract. However, you should take note that the disease must be prejudicial. Example of a non-prejudicial condition could be diabetes, because it's not communicable, or unlike of tuberculosis or of hepatitis. So, and other analogous cases which based on the listing. Now, on the part of the employer, in case of misconduct on the part of the kasambahay, or any willful disobedience, you have to consider willful and in relation to a lawful order and in connection with the former's work. Or it refers to the kasambahay, which means that if the order is not lawful, or if the order is not connected with the domestic workers' functions, then the employer cannot pre-terminate the contract. You have also to consider gross or habitual neglect or inefficiency of the kasambahay. As we discussed in the first lesson, the kasambahay must render work on the in favor of the employer, and the same must be sufficient, or the performance must be done well. And in case of fraud or willful breach of trust as reposed on the employer, you have to remember also as to the privilege and confidential information that must not be disclosed during employment. So if the employer, the kasambahay, breach this prohibition, then the employer has all the reason to pre-terminate the contract. Now, the commission of a crime by the kasambahay against the person of the employer. For example, if the kasambahay hit or physically abuse one of the children of the employer, then that could be a ground, and any violation of the contract on the part of the kasambahay, and if and when the kasambahay, or as mentioned, any disease that will be prejudicial to the parties involved. Now, what about the PIA? This is we're almost done with our second part. The PIA is an agency or a business, it could be an individual, a corporation, or a partnership, engage in the placement and deployment of Kasambahay. Now, the licensing and regulation is done through the DOLE, or the Department of Labor and Employment, and you have to take note of the liability of the PIA, which is jointly and solidarily liable with the employer. So in case of insolvency, or in the absence of the employer, like the employer absconded at the expense of the Kasambahay, then the Kasambahay can run after the PIA, or private employment agency. Now, any terms or any regulation or prohibited practices not mentioned in this law, you have to refer it to the Labor Code or Presidential Decree number 442. Now, the responsibilities of the PIA are as follows. It has to it should ensure that the Kasambahay is not charged of the recruitment or placement fees, because it is charged to the employer, and also that the agreement of the Kasambahay and the employer are in accordance with the law, and it conducts also pre-employment orientation briefing in the presence of the Kasambahay and the employer, so that they will know the duties and responsibilities and even rights under this law. And also this is very important, because aside from the parties, the PIA must, if the Kasambahay was placed or deployed by a private agency, then the PIA must have a copy of the contract, and it should be available whenever required by DOLE or the LGU officials. This is like, for example, what if the social municipal social worker will investigate in the working condition of the Kasambahay, then the contract must be provided by the PIA. And also, it also assists in complaints and grievances, and even in rescue operations. This is when there is abuse or exploitation on the part of the Kasambahay. Now, we already we are done with our second part, and I hope you learned so much from this, and I look forward to your attention also for the third part of this lesson. And I hope that you are in good health, and you are you are also seeing the positive side of this, of the ECQ, and I look forward we all look forward to the lifting of this. And for now, I bid goodbye, and have a good night.